Ms. Tucker, we'll hear from you.
Thank you. Mr. Chief Justice, and may it please the Court, this case presents the question whether dying citizens in full possession of their mental faculties at the threshold of death due to terminal illness have the liberty to choose to cross that threshold in a humane and dignified manner. Does our Constitution endow government with the power to intrude into...
You say they have the liberty to choose, but no, as I understand, there's not an issue here. Any patient choosing to die or to commit suicide, it's that they want assistance from a physician to do it. That's what we're arguing about.
That's correct, Your Honor. And the reason why we are focused on that is because these dying patients want a peaceful death, they want a humane death, and they want a dignified death. And in order to access that kind of death, they need the assistance of their physician. The physician is the gatekeeper for the medications that can bring that peaceful end to the suffering that for these patients is intolerable.
Ms. Tucker, why is it limited to those on the threshold of death? I mean, suppose I have, terrible pain, and the doctor says you're going to be in terrible pain for 10 years.
Your Honor,
why shouldn't I have the right to suicide?
Justice Scalia, we do draw the line at a patient who is confronting death. That individual has a very different choice than the one you posit. That individual does not have a choice between living and dying. This dying patient, whose dying process has begun and is underway, this individual has only the choice of how to die. Will that death be brutal? Will that death be peaceful?
I can tell you, but the dying process of all of us has begun and is underway. It's just a matter of time. And it seems to me that the patient who has 10 years of agony to look forward to has a more appealing case than the patient who is at the threshold of death.
Well, I think not, Justice Scalia, because the patient who is facing this question of how to die, this is the final decision for this individual. This is a patient who physicians do not have the difficulty that the state would suggest in determining that, in fact, the dying process really is imminent at this point. Now, keep in mind, in the record in this case, it was never disputed that these patients who came forward to bring this case were, in fact, quite close to death, and then subsequently all did die. There's no dispute in the record about that. The physicians each testified in both of these cases that it is their regular medical practice to make that diagnosis, and of course we know.
You said on one end of it that it's got to be at the terminal point of life, however one defines soon to die. And that's not as clear. But what about the person who is in such agony that that person is not able to assist in her own suicide, so she needs the doctor or the nurse to administer the lethal dose? Isn't that person in a more sympathetic situation than the one you're describing?
Your Honor, we don't believe that that class of persons in reality would exist. We believe that any patient who could fully express their wishes with regard to this end-of-life choice...
Let's take this person. I'm in agony, but I just can't do it myself. Please do it for me.
I see your point. I think you are describing someone who just can't bring themselves to do it, as opposed to having
but wants it, and 6 psychiatrists will swear that that's the mental state of that person.
Your Honor, we would posit that that is not permissible, that self-administration does address an important state concern here, and that's the concern of voluntariness. We agree that this decision should always rest with the individual and that it should be authentic and voluntary. And to require the individual to not only make this choice, but then to take the final act, we believe assures voluntariness in an important way.
Now,
so we would not...
Everything that you've said, it seems to me, could go on in a legislative chamber. Where should we draw the line?
Well, again...
To say that as a matter of constitutional due process, you include the person who is able to take the pill herself, but exclude the one whose mental state is the same, I don't understand how you get that line out of a grand due process clause.
I think, again, in the constitutional analysis, Your Honor, we are considering the state interests as balanced against the patient's interests, and because voluntariness is so essential here, an additional guarantee of voluntariness tips that balance differently. And I would posit that when the patient is fully mentally competent, is making a reasoned and deliberative decision, and is able then to take final action on that decision, that the balance clearly tips in favor of individual having the right to exercise this choice.
Why should that decision, if it's competent, reasoned, and deliberated, why should it be limited to physical pain? What about the patient who has terrible emotional suffering in life and just says life is not worth it anymore?
That is,
you would not allow assisted suicide in that case, I take it.
No, Your Honor.
Why is that? Because the government makes the judgment that physical pain is worse than emotional suffering?
Your Honor, mental competency and freedom from a mental disability or instability, including such as a condition like depression.
You don't have to be unstable to think that your life is not worth living, do you? Or is the government going to make that judgment?
I think that mental competency here is a bright line, and that that decision as to whether the patient is mentally competent, of course, is a clinician's judgment.
Assume mental competence and assume a patient who is thoroughly mentally competent, is not at the threshold of death, is not in physical pain, but does not want to live anymore.
Well, and again, that patient is not confronted with the choice that we address in this lawsuit.
But I'm asking how can you limit the choice you're presenting to us to the physical pain situation?
That individual, if intervention occurs and is not allowed to make this choice, may one day rejoice in that. It is an individual who has an expectation of life that could then be a fruitful and fulfilling life, which is not the case with a patient whose life is ending due to the progress of terminal illness. That patient has an entirely different character of interest. And I do want to address what...
And you're willing to have the government impose that judgment, even though the patient says these emotional scars will never heal.
I believe that the constitutional...
And I've tried it for 10 years, I want out.
I believe that...
You're willing to let the government make that judgment for the person, but not willing to make the judgment that your physical pain is not as harmful as a few more years of life would be. You're not willing to let the state make that judgment, but you will let the state make the judgment your emotional pain is not important enough.
I believe that's an entirely different case, Your Honor.